Thank you so much, both of you. Professor Clark, I was curious, do you think there's a danger in trying to delegitimize the International Criminal Court and other international bodies of justice, in that the idea that it might give more power to criminal governments? And I was curious about your Uganda example, which was very brief, where in that case I would say that I would support the International Criminal Court's work, and that the Ugandan government itself, many people think, has been complicit with the Lord's Resistance movement in northern Uganda, and has, if not channeled funds, then at least, ignored some of their activities over the last couple of decades. So it concerns me if we, throw these international justice bodies out the window, and we're assuming that, some local or state processes are legitimate. And I think in the Nigeria case, not in that case in particular, but I mean, most people I know who are Nigerian or have experience in Nigeria would not put their full faith in the local justice bodies, and so would want some kind of either a back and forth or at least some relationship outside of Nigeria to help ensure that the local processes are with integrity.
Okay, so that's a loaded question in many ways, no quite political one, but
Right.
I welcome it.
This is what we do here.
I welcome it. So is there a danger to delegitimize? How do I respond to that without being defensive? I'm not delegitimizing. I'm engaging in critical engagement. And in fact, one of the things that I say at the beginning of the book and in the beginning of the many articles is that I'm not writing against human rights. I simply think we can do it better, much better. And I think the example around the mobilization of feminists with the Amina Luwal Safia Husseini case is an example of that, the need to work much more effectively to communicate with those for which we claim we're helping. What about the communication, as basic as that? What about collaboration that involves finding out what one needs and how to deploy forces to their aid? So to engage critically isn't to delegitimize. That's the response to the first. And I think that's important for us to reckon with. The second has to do with local processes. I don't think that that's the way to go about making human rights systems better, to simply be skeptical about local justice systems. In fact, the Nigerian mechanism worked effectively. Amina Luwal and Sophia did not die. And although what we saw, I mean, many of us read these internet postings and took from that after the court's holding of the death by stoning judgment, she was immediately going to be stoned, either Amina or Sophia, which wasn't the case at all. Nigeria has a quite complex legal system, the last of which is the Supreme Court constitutional. And so there are steps, just as there are in the U.S. adjudication, and so I think the importance here is to educate ourselves on what these fundamental steps are within these local processes. And to participate or look at the ways in which people are working on capacity building in a range of regions, and work with them. So you bring up the Uganda case. I have a couple of chapters on Uganda. It's certainly, for those of us who write about and are interested in international criminal law, the Uganda case was the first case before the court, and continues to be, or at least it wasn't the first case, but it was the first case for which, the first moment in which arrest warrants were released, and they have not succeeded, of course, the warlords are still at large, but there are a lot of incompatibilities in Uganda's justice system, which makes even the ICC's jurisdiction questionable. And what is needed, I think, in the Ugandan case isn't simply to embrace the ICC wholeheartedly, it's to think fundamentally about the ways in which the Ugandan capacity needs to be rebuilt. Because beyond the ICC adjudicatory measures of taking on 3 or 4 warlords, then what happens? Do we simply go to international institutions or multilateral institutions each time there's a problem? No, I think to think long term is to think about the strengthening the capacities, thinking about rewriting or even amending laws that are in conflict with the statutes and treaties that are being signed by these countries. And so there's a lot of infrastructural work that needs to be done, and I think that that's where the rolling up the sleeves and getting active with collaborative work, those who are working with NGOs and others, this is the kind of work that needs to be done in this regard.
Just a friendly amendment to that. This is not a new question about sovereignty and jurisdiction over crime with an overarching body. We dealt with that very same question in the 18th century, and we were trying to figure out the division between federal and state authority over the punishment of crime. And the solution that was ultimately reached in the American context was to leave sovereignty over criminal law enforcement at the local level, at the state level, but to put in place a series of procedural human rights safeguards articulated clearly in the 4th through 8th Amendment Bill of Rights, and then amplified further in the 14th Amendment due process and equal protection clauses, all of which are simply to say the mechanisms at the local level can continue in place. We will respect the sovereignty that the individual states have, even if they differ in part in the way that they implement basic understandings of criminal justice, but we will have certain overarching non-negotiables in human rights procedural terms that cannot be trespassed. And over time, that negotiation over two century plus period has been, there are certain things that the states don't do well, and we've created bodies of federal criminal law to overlay the individual state laws, and we have a body of federal crimes now that get enforced in the federal courts. And in many ways, I think what we're going to see in the 21st century is a bit of the same exercise at the international level. Individual sovereign nation states are going to have basic jurisdiction over criminal matters. There are going to be a set of human rights constraints imposed by their own local state constitutions and the international treaties that they ratified. And then the question is going to be whether there are overarching bodies in the ICC or some of its eventual progeny that are going to provide oversight and ultimate appellate authority to ensure that local processes for sovereign purposes don't trespass fundamental universal human rights that cannot be trespassed.
Right.
That's an interesting historical analogy.